and was fixed after 4 weeks.
August, 7th August.
7th August.
Made, please, your lordship. Lordship, I pray for listing of an IA tomorrow, your lordship.
Right, tomorrow.
Lordship, the connected matters, the connected IAs were asked to implement the selected candidates, your lordship. So, lordship, the other connected matters is listed as item number 10 and 11 tomorrow, your lordship. So, I pray the matter may come up together, your lordship. And lordship, secondly, I have another prayer, lordship, listing of an writ petition on Monday, your lordship, for admission, your lordship.
Why Monday? 11 on 26th.
26, lordship.
May please, Lordship. I am praying for listing the matter on admission column on 24th Monday.
Why?
Let's
26, 26.
yes. Matter, your lordship. I'm praying for a listing of a fresh matter for tomorrow, my lord. The urgency is that your lordship, this is a review petition, my lord. Your lordship was pleased to pass an order on last month, 26th of June, my lord. They were disposing of the matter, directing the Director of Education to pass a speaking order within a period of 30 days from 26th, my lord. So the director may pass any order, my lord. This is against my B.Ed degree, my lord. So the director may pass any order within a period of 30 days, my lord. Already 20 days is gone, my lord. So the urgency is there, my lord. Tomorrow, my
So
lord.
what urgency is there?
Lordship, it is a review petition. On the last occasion, the last month, 26th of the June, my lord, your lordship disposed of 3 petitions. Thereby directing the Director of Education to pass a order, therefore verifying whether my B.Ed degree is valid or not. That is the degree. I'm a respondent in the review writ petition, my lord. So since vacation was there, my lord, so the director can pass the order at any given date, my lord. Since your lordship has given a particular period of 30 days, my lord. So 20 days already gone by, my lord. Within 10 days, any date, my lord.
Have you informed the other side?
I hear lordship. Already copies are given, my lord.
Friday.
Lordship.
May I please, Lordship? Lordship, in item number 7, we have filed an affidavit, Lordship, which may kindly be called for, Lordship.
But please, Lordships. Lordships, mention item WPC 4537 update 22, Lordship. Last posting, Lordship 4822. Lordship, matter will be fixed for next week, Lordships. 4th August. Must.
Your lordship. I beg to mention item number 3 with the consent of the other parties.
What do you want?
Well, for the petitioner, the senior counsel, Mr. H.X. already underwent surgery recently, and he cannot appear to the lordship.
Have you taken?
On held ground.
On request made on behalf of Mr. H.R. Chowdhury, the senior counsel for the petitioner, please permit up to 2 weeks.
My lord, item number 3, can it be next week, my lord?
He had the surgery,
Yes.
so I'm having it after 2 weeks.
Okay. Yes. Lordship, in item number 1, on behalf of the B46, he has requested me to take a week's time to. He was supposed to file an affidavit, Lordship.
It's on the top of the list.
It's on the top of the list.
Why?
Earlier, several occasions, lordship, time was granted. Lordship, kindly peruse the order dated.
The last order I have seen, Lordship. And yes, this is action. But he has said a last 1 week time. He's here, Lordship. He's in court for 17 years gone, but he requested me to take a 1 week time for as a last.
2015 matter, lordship.
I'll give a fixed date.
Yes.
Next
Yes.
is the lordship.
Third M Khan when it comes to the petitioner. On request made on behalf of Mr. Lee Kaushik, then the standing council element department. List the matter on. Page what? 27th.
27.
I am for the respondent number
Mr.
SK Ghosh.
S.K. Ghosh, Senate Council appears for the response.
My lord, one thing maybe the further adjournment may not be granted, lordship.
So, motion.
Yes, Bhuyan.
My lord, may I please as your lordship? My lord, what has happened, my lord? The present petitioners are, my lord, B.Ed degree qualified from the CMJ University, my lord. My lord, these petitioners has challenged in speaking order, my lord, before this honorable court, my lord may be pleased to find the speaking order is at page 90, my lord, annexure 11. By this speaking order, my lord, the government has decided not to extend the benefit of B.Ed degree to those candidates.
Page.
My lord, page 90, my lord, annexure 11,
Page 90, Lord.
90, my lord.
Yes.
If may I read over a small part, my lord? Findings. It appears that all the petitioners of the aforesaid writ petitions are presently serving as the teachers, headmasters, in charge or principal in charge in some schools of the state. They approach the Honorable High Court seeking for a direction to the respondent authority to recognize the B.Ed degree obtained by them from the CMJ University, Meghalaya. Honorable High Court, by its order dated 13/9/2019, passed in the aforesaid writ petition, has given direction to the government of Assam in Secondary Education Department to pass a final order regarding validity of their B.Ed degree within a period of 3 months. In compliance of the honorable court's order, the department has obtained the reports, views from the University Grants Commission, Education Department, Government of Meghalaya, ERC, NCTE, Bhubaneswar. From the reports oblique views, it appears that the CMJ University Meghalaya is not recognized by the Eastern Regional Committee NCTE Bhubaneswar for the B.Ed program. Also, the said university was not authorized to open off-campus centers beyond the territorial jurisdiction of the state of Meghalaya, and also not even allowed to open any center even within the state of Meghalaya as per the provision contained in the UGC Establishment of Maintenance of Standard in Private Universities Regulation 2003 without the approval of UGC. Order. After careful consideration of the above and all other aspects, the government of Assam in Secondary Education Department has decided that the B.Ed degree obtained by the petitioners from the CMJ University cannot be recognized as a valid for the purpose of employment and promotion. So, my lord, they have taken a conscious decision, and my lord, this speaking order had been put into challenge before this honorable court. My lord, may kindly turn to page 93, my lord. And page 99 is the relevant part, my lord. My lord, I am sorry to bring into the notice of this honorable court regarding this order, my lord. Situations are as such, my lord, at this moment. Heard Mr. So-and-so, my lordship has given an extensive hearing, my lordship. And now, my lord, we are waiting for the judgment, my lord. Now, what has happened, my lord? The government has initiated a recruitment process for the purpose of promotion by this letter at page 100, annexure 13, my lord. This is a letter issued by the director to all the concerned inspector of schools, my lord, regarding submission of the gradation list of eligible teachers for promotion to the vacant post of headmasters of provincialized high schools. Now, my lord, on the one hand, my lord, we are awaiting for the judgment, and on the other hand, my lord, this process has been undertaken. Now, my lord, if this process is going to be, my lord, completed, then, my lord, if in the meantime, my lord, our case may be allowed or dismissed also, my lord. That is the outcome, we don't know. Now, my lord, if this process is going to be completed, then, my lord, we will be ousted. So, my lord, our limited, my lord, and a very limited prayer before my lordship is that, my lord, let the department carry on the exercise of promotion, my lord. Our candidature may also be considered, and our results, my lord, the outcome of our candidature may be, my lord, my lordship may be pleased to observe that that should be the final outcome of the judgment which is going to be delivered, my lord. That much interim protection, my lord, we are seeking, my lord.
That cannot be given because their degree is not very lordship. Even the NCTE in the affidavit filed in the earlier case lordship that is pending, they have said that they are not recognized lordship. So how can
See,
they?
Jisti,
Yes, your lordship.
the judgment is still awaited.
Yes.
We don't know what will come.
My
Yes.
lord, my lord.
So in the meantime, let them participate in the examination,
Fine.
but their participation shall be subject to the judgment passed in this petition.
Yes. Well, if that is allowed lordship, then all CMJ degree has already
No,
been
no,
valid.
no, I'm not saying that,
Blanket is cannot be, my lord.
I'm not saying that we are allowing that
Take it as a
the,
precedent lordship.
it is not a precedent. Just allowing the petition to participate,
My lord.
Lordship, this is just a
but
letter
their
for.
participation shall be subject to the outcome of this.
Let me first
petition.
take instruction whether that any initiative has been taken. This is a letter to file, submit the graduation list. Let me take instruction, let me come on Friday, let's know.
Okay,
Yes,
okay.
that will be better.
Third, A. Boyan, and counsel for the petitioner. Mr. SMT Chisti, then standing counsel, secretary,
Secondary education.
education, place for some time. We take instructions as to whether any steps have been
Yes.
initiated for,
For promotion to the post of headmaster.
for promotion to the post of.
My lord, may I interfere, my lord?
1 minute,
My lord.
pursuant to the, where's that
My lord,
letter?
letter dated page 100, my lord. Letter
Last,
dated
last annexure lordship.
last page of the petition.
Pursuant to the letter dated 1st June 2023. Written by the Director, Secretary Education, Assam.
My lord, actually, the same order was passed on the very first day, my lord. For the instruction, and Mr. B. Kaushik appears, and on that day, my lord, he says, my lord, that there is no possibility of the finality, my lord.
Let me take it, let me come on Friday. I will.
List the matter again on Friday, you want?
Yes, yes.
Yes.
Are you sure?
Today is 18th, Friday lordship, no. Don't lordship, take it up on 24th lordship,
On 24.
24th.
Obliged.
For
Admission.
May visit the lordship. Lordship, in this matter for the last 10 months, affidavits are not coming forth.
yes. Who appears?
And it elementary and health is also there, lordship. I don't know, but I.
Who appears for elementary education?
Elementary lordship, I will appear lordship.
Are you filing your affidavit or not?
I haven't gone through the records, lordship. We have not.
Lordship, in case they are not willing to file it, lordship may fix it for admission hearing.
The records are also, we have unable to trace their lordships.
Oh.
Oh, yes, lordship. Mr. NJ Khatne last time submitted that he has received a paragraph comment. So lordship may kindly give it 2 weeks time, lordship. I think I will inform him, lordship, to file the
Lordship, can you
affidavit.
fix a date for admission hearing and in the meanwhile.
Third,
they can file
MS
it.
and Begum, then counsel for the petitioner. Mr. SMT Chisti, then standing counsel elementary education. Submits that he has received the paramount comments. And place for 2 weeks time to file counter. Praise the Lord. I'll give you a fixed date.
Lordship.
Lordship, Mr. NJ Khatne has received, I will inform him, not fix their lordship after 2 weeks.
Lordship may kindly fix the date. They have been delaying it for quite long now. It was lordship's order way back in October last year.
8th August.
Lordship,
August, yes, yes.
much obliged.
I.
May I please your lordship? Lordship, in this matter, we have already filed the affidavit, and in response to that, affidavit in reply has been filed by the petitioner, my lord. On yesterday, they have filed that we have not received the copy.
No, my lord, I have served not. My lord,
Yes, served.
Your lordship
served the
also
copy
targeted
on the office, but I have not received.
Have you filed your reply?
yes, my lord, I served.
When did you file?
Yesterday and just before.
After the lunch
your
in
lordship
second half.
targeted me to bring on record.
That's
Has
all.
it come? Not yet.
So after some time, my lord, after some, it will come, my lord.
Have you received a copy of the reply?
No, he has served the copy on the office, but till this time I have not received it.
Then there's no point.
I have served, my lord, to their office, my lord. It is not. So, my lord, after some, time, my friend will get also.
Yes, you Shama, are you ready?
No, my lord. Reply has filed yesterday, my lord.
We have to find it out, lordship. There is some other lordship.
Yes, my lord, I have filed yesterday, copy has been served. So, is there any point, my lord? So after some time, my friend will definitely get.
No.
He
We have
is
to
not
go
in a
through
posi-
it.
He's not in a position to argue the matter today. That's what he's saying.
Otherwise, my lord,
I have to send it to department, my lord, whether their response.
my lord, I have filed reply. They have filed opposition, my lord. I have filed reply. Even if without reply, your lordship may consider my case, my lord.
I'm the affidavit.
My lord, I am on the rule, my lord. Very, my lord, this petitioner, my lord, since to 10 years.
It's a big reply. It's a big reply. Have you given a?
I have served, my lord. There is.
Have you received a copy, Mr. Yu Sharma?
Till now, I have not received the copy. It is served on office, my lord.
That is why
The
service.
office have to keep it in the file, lordship, that he has filed yesterday only.
Yesterday in the evening.
Sometime we can be
Then
given,
why
lordship.
are you pushing so
Why
much,
so
Mr. Kanta?
My lord.
But Mr. M.R. Kandakar, legal counsel for the petitioner. On request made by Mr. Yu Sharma, the standing counsel, Secretary Education Department. How much time you require?
2 weeks, my lord.
My lord, next week, my lord, next Monday. This person is since 10 years, my lord, on the same ground, 3 times rejected, my lord.
Okay. List the matter after 2 weeks.
My lord, any date, my lord, maybe. Pleadings have been completed, my lord.
10th August.
10th.
I am okay.
7 order.
May I pray this matter may be taken after some time, Lordship. Lordship, in this case, I am filed one incomplete petition, Lordship, that is under process, Lordship. Let the matter take up day after tomorrow, Lordship, or Wednesday, if
Day
possible.
after tomorrow.
That is under process,
My
Lordship.
lord,
One
let it
petition I am
come
going to file.
on Tuesday, my lord, next Tuesday.
Lordship, we have some.
We have also received the instruction, paragraphs, comments, lordship. We'd like to file our affidavit. It may come up the 3 weeks.
Next Tuesday, my
Lordship,
lord.
may I pray, Lordship? Lordship, we have some urgency in this matter. The teachers and the staff are not getting salaries since last 2-3 months. May I pray the matter may be taken after some time and after hearing my senior Lordship may pass any order. After some time, Lordship, he is on legs in group number 13. Most obliged.
8 and 9.
Item number 8 and 9, my lord.
Why is it coming for orders?
My lord, the suspension, my lord, there are 2 cases filed. One is the suspension case, my lord, which is the first item. My lord, the person was placed under suspension. It was last extended on 10th of April 2023.
No, but why is it coming for orders?
My lord, it was coming up for consideration because the second petition which has been filed challenging a disciplinary proceeding, a stay was granted there. Respondents were to file their reply because I have made personal allegations against the disciplinary authority, the inquiring authority, and the person who has been issuing me the letters. No reply has been filed till date, my lord. And there are orders that no adverse orders will be passed during the pendency of the repetition. They have not come up with anything. In the meantime, my lord, what they have been doing, therefore it was fixed on today, my lord, for their reply. In the meantime, they have been communicating with my client, directly asking them how we can make allegations in a repetition. One of the charges in the memorandum of charges that I have approached this honorable court against my suspension. That is a charge against me framed by the respondent authorities, my lord. So that is the level at which malafide and bias is acting against me to put me out of service, so that the director of the institute, who was supposed to have given up his charge way back in 2007, has been continuing till now. Just one point on the first repetition, if lordship allows me, one thing, the suspension perhaps will not sustain now. If lordship has the first repetition, my lord, 7524 of 2022. 7524 of 2022, my lord. But in this case, the repetitioner was placed under suspension on 14/10/2022. I'm sorry, 12/10/2022. Lordship will find the order at page 62. At page 62, Lordship finds the order.
Yes.
10 October 2022, my lord. Thereafter, it was extended on the 10th of January 2023.
before the, on the 90th day of the suspension. Next, my lord, I have just placed the 2 copies, my lord. He was thereafter extended, the suspension was extended on 10th of April 2023. Now, my lord, per the rules, it was to be done, any extension, further extension was required to be done within a period of 90 days. A mathematical calculation will show it expired on the 9th of July, 2023. On the next page, lordship will see 12th of July, they try to extend it again by 3 months. No, my lord,
They are extending something which is not.
my lord, they are extending something which is not as of date extending on the date of the
Existing.
extension. If lordship kindly has the Supreme Court judgment, my lord.
Which case?
My lord, the Deepak Mali case, my lord, which specifically says that once it is not done within the 90 days period, it cannot be extended. It has to come to an end. The person has to be allowed to join, my lord.
My lord,
What happened to me?
I'm appealing for the respondent want to fix my lord. I want to file my.
Before he starts,
In this case,
you
my
can start
lord,
once I finish, my lord, my submission.
in this case, my lord,
The judgment, my lord.
service on the respond number 6 has not
That
been
is separate.
completed, my lord.
One minute.
That is a separate chapter, my lord. Lordship has the judgment, my lord, Deepak Mali. Lordship may like to come to paragraph 11 of the judgment. The case, I'm sorry, my lord, para 10. Having carefully considered the submissions made on behalf of the parties and also having also suspension of the relevant dates relating to consider the respondents, and when the petitioners came up for review on 20th of October, we are inclined to agree with the views expressed by the Central Administrative Tribunal as confirmed by the High Court that having regard to the amended provisions, sub-rule 6 and 7 of rule 10, the review for modification or revocation of the order of suspension was required to be done before the expiry of 90 days from the date of order of suspension, and as categorically provided in sub-rule 7, the order of suspension made or deemed would not be valid after a period of 90 days unless it is extended after a review for a further period of 90 days. The case sought out to be made on behalf of the Petitioner Union of India as to the cause of delay in reviewing the respondent's case is not very convincing. Section 19(4) of the Administrative Tribunal Act speaks of abatement of proceedings once an original application of the state aid was admitted. In this case, what is important is that by operation of sub-rule 6 of rule 10 of the 1965 rules, the order of suspension would not survive after the period of 90 days unless it was extended after review. Since admittedly the review had not been conducted within 90 days from the date of suspension, it became invalid after 90 days. Since neither was there any review or extension within the said period of 90 days. Subsequent review and extension, in our view, could not revive the order which had already become invalid after the expiry of 90 days from the date of suspension. For the said reasons, we are not inclined to interfere with the orders passed by the High Court, and the special petition is dismissed. Now, my lord, if we take 10th of April, 20 days in April, May we have 30 days, 50 gone. June we have 30. June we have April we have April we have 20 days. May we have 31 days, 51. June we have another 30 days, 81 gone. So in July they got it up to 9th of July. 9th being a Sunday, 10th was the best day. They issued the order on 12th. So the suspension by operation of law, my lord, it does not exist now. It has to go. He has to be allowed to join. And my lord, my allegations regarding the malafide in suspending me, that may be decided by this honorable court. That is another issue. But as of today, my lord, the suspension cannot be extended by them, and it has to go. I have to be allowed to join, my lord.
My lord, in this case, I shall file an affidavit. Already 58 paragraph, my lord. It is a voluminous, half done.
Suspension affidavit.
So matter will be taken up with another case. Next day, my lord.
In case the suspension period is over.
My lord, we have filed affidavit in another case, same case, my lord. And
Suspension case they have filed.
and they also filed this case, my lord, challenging the validity of the holding of post of the director. In this case, my lord,
No, what do you say on the suspension?
my lord,
What do you say on the suspension of the petitioner?
petitioner, my lord,
DP is going
It
on my.
expired on 9th of July, 90 days. Since 9th was a Sunday, you could have reviewed it on 10th. That was not done. You did it on 12th. So by then the suspension period is over. Suspension.
8th of July, this is the meter of IO, my lord.
What?
IO. Means, my lord, the institute was earlier established by the government of Assam, my lord.
I'm not talking about the establishment of the institute or this thing or that thing. I'm talking about the suspension of the petitioner.
Suspension, my lord.
With the lapse of 90 days, suspension stands revoked.
My lord, within 90 days, we have filed a search with my lord. We have filed charge with my.
I'm not talking about charge sheet. I'm talking about review of the suspension order.
Suspension. my lord. DP is going on, my lord. Suspension.
DB is going on, that we understand.
Yeah.
But the period of suspension of the petitioner.
Restraining the petitioner from.
Yes.
My lord, the DP, my lord, will not interfere because this honorable court has also granted them liberty. DP, there are many illegalities, my lord. I brought it on record. This honorable court had directed them, you proceed with the DP, don't pass final orders. That interim order is in the second case. Here, my lord, the issue is whether I should be kept under continued suspension. Now, the law is well settled. Once that suspension order period is over, you cannot, my lord, extend something which is already dead. That's what they are trying to do here, my lord. So, my lord will only interfere to that extent, say, in terms of the earlier order, let them continue with the, my lord, departmental proceeding. And, my lord, therein there is an order that there will be no final orders. That much, my lord, no prejudice will be caused to them, my lord.
Yes, counsel.
My lord, because he has stated some procured some documents, official documents, which is stated in this petition, my lord. That which is
No, we are not on this issue. We are on the issue of the continuance of the suspension of the petitioner. The
My lord,
continuance of the
that
suspension of.
delay has occurred due to non-cooperation or non-cooperation of the petitioners.
What non-cooperation of the petitioner? Are you supposed to review with the cooperation of the petitioner? The
Non-cooperation,
suspension
my lord,
order?
because we asked for some documents from him, but he has not cooperated.
That is with regard to
My
department
lord,
proceeding.
now he is cooperating with the DP, my lord.
I'm not talking about the DB. I'm talking about the suspension of the petitioner.
The review was
The suspension of the petitioner, you are supposed to review every 3 months, correct?
3 months, yes.
Thereafter extend the suspension or revoke the suspension order.
Yes,
So you have been extending it from time to time.
time to time.
Last extension was in 10th of April.
July.
April. All right.
Uh.
After that, 90 days expires when? 9th of July. 9th of July, isn't it? So since 9th was a Sunday, you could have reviewed it on 8th, or you could have done it on 10th. But then on 12th only, you reviewed the order and then passed.
Yes, my lord.
So
My lord, in this issue, my lord, I have to take the instruction. Whether
what
they have
instructions
reviewed-
is required? This is a question of law only.
Whether they reviewed it subsequently.
So the order is here, the order is here. 12th of July,
July.
2023.
And this is the most important thing.
Isn't it? Let
It is
him come
required.
prepared, Mr. Nair, let him come prepared. We'll take it up day after tomorrow.
Day after
Yes,
tomorrow.
my lord.
No issue. No issue.
I am not prepared, my lord. Okay.
Why are you
Because-
coming unprepared when the matter is listed?
Because it is come for orders, my lord.
Whether it is orders, admission or motion, all cases you have to come prepared.
My lord, that suspension matter, only a order has to be passed. My lord will keep it for further hearing on Thursday, my lord. Because only that reply is to be there, my lord. Otherwise we have completed the argument.
Only 2 days maybe.
Thursday.
2 days may be given. I will
Thursday,
leave them after 2 days, might.
So Thursday,
Thursday.
isn't it?
In the meantime, we shall take the instruction.
But you can add a senior counsel assisted by Mr. R. Madhukar. On request made by Mr.
AK Datta.
A.K. Datta, Leonard counsel for respond number.
All the respondents.
You're the standing counsel.
Yes, my.
He is CGSE, he is CGSE.
Leonard, you.
My lord, in
It's the matter.
item number 8, my lord, except 6, my lord.
No, no, no. My lord is in item number. Item number 8.
List the matter, you cannot. Friday, Thursday is 20 July.
Further hearing. For further hearing, my lord.
Go for the-
And my lord, in the next case, my lord will fix it along with this. And my lord will only extend the interim order.
I'm passing a common order in both.
Lordship, because there is an interim order in the second case, my lord.
Interim order passed in WBC number
Number
3858.
3858 of
2023.
2023. I'll continue till the next. week.
much obliged.
14 of supplementary order.
I don't.
May I please, your lordship. Lordship, may kindly peruse the order dated. Last order, lordship, passed by the Lazima court, lordship. 17/7/2023, lordship.
Can you take dusty service? Can you take? Mr.
M. Ahmed.
M. Ahmed, legal counsel for petitioner. Pays for taking dusty service on the respondents train for. Stop. Prayers allowed. Petitioner directed to post service of notice on respondent train for by dusty service to the register of this court within a period of 1 week.
Yes, sir.
One week from the date. Thereafter, petitioner shall file an affidavit to the debtor. List the matter after 3 weeks.
Highly obliged.
10 of 15 is hearing.
Item 10, Lordship, may kindly take it after some time, Lordship. Mr. Arbora, standing counsel, he says she is on the way, Lordship. She has some instruction. She requested me to take positive for the time being. For the
13,
May it please, lordship, my lordship, my senior is in court number 1, lordship, may kindly take up after some time, my lord.
Sometime after sometime, our vote is over. Love item 7. It has come.
7. Item 7 order.
At 2, lordship. My senior has not completed the hearing as yet. At 2, lordship.
have to file our affidavit, Lordship.
Let it come up, will come.
At two, Lordship.
Oh my God. Any part two matters? Anybody for part two? All these matters at 2 o'clock.
Now in a very situation, may not that they are not getting their salaries and all because of the confusion arising out of the order passed. Your Lordship, kindly see two orders of the Honorable Court, my lord. I'll just take your Lordship to those orders. There is no interim order as such, but then the court indicated that the order should be passed. That is the problem, my lord. Lordship will kindly see page 37, first order. First order. Well, this Lordship, the other side has filed an application for implement also. I'll
Lordship,
understand.
that is under process, Lordship.
That is under process, and the government also may like to say, file something. Lordship may not hear them. The Lordship will kindly give us some protection because the teachers are not getting salaries this last 4 months. And the grade 4 staffs are also not getting salary. Lordship will only indicate that. Lordship will kindly see page 37. Heart so and so. I'll read the third paragraph. It is stated that Silchar College School, though a non-government education institution amenable to jurisdiction Assam Non-Government Education Institution Regulation 2006, as well as the Assam Non-Government Education Institution Regulation 2007, society and a society registered. The society is not a society as such. The Deputy Commissioner dated so and so interfered with the constitution of the managing committee and the non-government education Silchar College so and so. It is submitted by that the Deputy Commissioner Kachar has no such jurisdiction and authority to interfere the constitutional managing committee and non-competitive institution. Hence, this petition is filed setting aside quashing the minutes meeting dated 11/10/2022 regarding constitution of the managing committee of the school and interfere so and so. Let on 31/3/2023 on the said date, Deputy Commissioner Kachar, defendant number 2, respondent number 2, shall apprise the court under what authority and jurisdiction exercise of its power constitution managing committee said Silchar so and so and non-government so and so. The other prayers of the petition, including the interim prayer, shall be considered the next date on receipt of this so and so. My lord, next order is at page 40. This is the order, my lord. Hard so and so and so and so. By filing the writ petition under 226, the Constitution of India, petitioner has challenged the minutes of the meeting dated 11/10/2022 held in the conference of Deputy Commissioner. By a resolution made in the said meeting, amongst others, all activities relating to school was ordered to be taken up by the managing committee. Respondent number 3, who is an ACS officer serving as an executive magistrate Kachar. The petitioner has referred to the decision taken in the previous emergent meeting of the managing committee of the said school held on 30/9/2022, whereby it was resolved to nominate the petitioner president of the reconstituted managing committee, by which granted the nominated persons. Issue notice, return petitioner shall take steps. Now the next page, my lord. As the instructions were not received by the learned government despite the orders and so, having regard to the provision 20 or 21 of the so and so regulation 2006, this court is inclined to suspend operation of the resolution meeting dated 5 p.m. in the conference hall so and so. In terms of the order, the government will obtain instruction. So it was only the court has indicated this court is inclined to pass this order. So this order has weighed heavily on them, my lord. Next page, my lord, kindly see the letter written by the president. I mean the so and so who was the president to the DC. Very respectfully, I like to state that due to the order passed by the honorable court dated so and so, school has come to a jolt, though the school is being run till now with the untiring efforts of the headmistress of the staff. It is not possible to carry on the day-to-day activities more, if any, more. Staff salary, telephone, electricity bills are pending. As on the one joint signatory of the bank operations is the respondent in the writ petition, Sri Rajiv Kumar Datta. Even day-to-day classes activities of the school has also become effective, as there is no scope for spending money due to the order of the honorable court dated so and so. the first unit test exam from lower class 10 will be held in the first part of the June. Unless the order passed by the High Court is vacated, at least interim order is given. So and so students. The next page, my lord, this is important, is written by the headmistress of the school, my lord, this page 43, my lord. Kindly, this is very important, my lord. She has written letter to us, my lord. In fact, she is not made a party. School is not made a party. So, madam, in reply to the letter from your association, this is Teachers and Staff Association, I'd like to inform you that I have not been able to release staff salary for the last 2 months. It is now 4 months, my lord. And I am also unable to continue with the necessary development works of the school due to the confusion created by the order of the Honorable High Court dated 31st March 2023. As you all know, due payments related to our day-to-day works and also like electricity, telephone bill, internet bill, other government payments, etc., are pending. In the middle of the June, school has to hold first unit test for more than 2,000 students. The preparatory works involve huge expenditure for starting HS classes, also need to huge amount of money for the proper infrastructure development. We have to start class 11 soon, as school has got permission from the Assam Higher Secondary Education Council, and if we do not start class 11 this year, permission may be cancelled. Construction of nursery block is half done, as payments cannot be made. I am in much trouble as managing committee is not working because of the order of the Honorable Court dated 31st March 2023, which has created confusion in our minds. Unless High Court provides relief to our confusion, doubts is dispelled, I shall be in great problem. Despite my untiring efforts to run the school amidst all activities, I shall be able so and so. So, my lord, my prayer before this, before Lordship is, my lord, this Teachers and Staff Association on the one hand, and the Guardian Association on the other hand, they are at loggerheads, my lord, they are opposed to each other since 2014. And since 2014, by a clause provided in their bylaws, the DC has been, the district administration has been, my lord, helping to run the administration. The additional DC has been made president of the, though under the rule they cannot, but then this problem, there is a bylaw provision which says in case of such disputes, such differences, such a situation, we will approach the, therefore both students and teachers have been approaching the DC and he has been solving the problem. That is how the DC has come. Now, my lord, my prayer before Lordship is, Lordship will only clarify the order and give a direction, my lord, that the headmistress may, till the matter is hard, till the next date or till the matter is hard, release the salary of the, staff and so, because he is not doing that, and or make the urgent expenses and keep a proper account of it, may submit before your lordship the account expenses they will make. Only administered may be the signatory of the, in the bank, because he is otherwise a signatory along with the president. But the problem is who will be the president is the dispute. Either the guardian or the DC or the from the student, that is the dispute is with regard to who would be the president. So, my lord, leaving aside that dispute, your lordship will decide that dispute later, after my learned friend maybe get pleaded and all. My lord, for the time being, your lordship will allow the headmistress to make to make expenses, urgent expenses, including the staff salary. That she has not been able to do. That she has explained, my lord. That is why, my lord. For the time being, either the headmistress herself only, or along with the, any other officer of the, not the president, because that is the problem. Headmistress or the inspector, along with the inspector, both may be joint secretary, inspector of schools, or the, there is other officer, the what it was, district mission coordinator. He is also an education officer there, my lord. He may be, or headmistress may alone make expenses, teacher salary, staff salary, and make urgent expenses like stationaries, telephone bills, and these expenses she can make. That is my only prayer before lordship today. And this, I think, my lord, this is a reasonable prayer for the students also, for the teachers also. This should not be opposed by my lord friend, at least, my lord. Expenses made by the, let the headmistress, maybe the signatory alone, or maybe along with the headmistress,
Yeah, neither from the guardian society nor from the teachers, maybe inspector schools, along with the both may be the signatory for bank transaction and all. That is the only prayer, my lord. Nothing more, my lord. Your lordship will decide the main issue later.
My lord,
Because this
may I
is
submit. My lord, the problem is created by themselves only. In terms of this interim order, there is a specific direction that the meeting held on 11/10/22, the court is very clear about it. It was illegal. And therefore, the implication is the original MC should have been restored.
Where is
Now,
this meeting minutes?
meeting minutes is at page 28 of my writ petition.
no, my lord. I have a next in my IA also. That is page 80.
Page?
80.
Yes.
May I read it, my lord?
Hmm.
Meeting presided over by Rohini Swanso DC. At the very outset, Deputy Commissioner Kachar welcomed the all Swanso. Initiating the discussion, Deputy Commissioner Kachar took stock of overall functioning of the school. Deputy Commissioner asked an apprised House about the formalities followed during the constitution new managing committee after completion of the term of the managing committee constituted in 2019. In reply, one member of the earlier managing committee informed the House that a meeting was held, but he could not be able to produce any documents showing about the meeting. Only resolution was placed before the committee. The committee members also failed to produce any evidence in support of the procedure followed during the selection of teachers as a member of the committee. The Deputy Commissioner Kachar also inquired about the role of guardian society in the school, but the members could not show any specific role of guardian society in the school. And after threadbare discussions, following points have been adopted. As it is evident from the submissions, the new managing committee was formed without following the procedure. The committee so formed has been declared cancelled with immediate effect. All orders of Srimati Shilpi Chakraborty in the capacity of secretary of the school stands cancelled with immediate effect. An internal complaint committee would be formed and headed by women faculty to meet the complaints regarding the molestation, ragging, and the so-and-so. The committee of the school to be formed with Srimati so-and-so Himakshi Deka AC as executive committee as president, headmaster or headmistress of the school as secretary, 3 teachers and 3 guardians to be selected as members by means of voting procedure. Srimati Himadri Deka, ACS Executive Magistrate Kachar, will take all initiative for constitution of the committee of the school and shall preside over the selection committee, teachers and guardians. One educationist shall be member of the committee of the school. Headmistress and Himadri Deka, ACS Executive Magistrate Kachar will be joint signatory for all financial matters in respect to the school. Teachers of the school shall remain abstained from providing private tuition to the students of the school itself. However, there will be no restriction in providing private tuition to the students of other schools. Regarding issue of transfer certificate of students, it is decided in the meeting that the concerned headmistress will issue the transfer certificate time to time and will be required. As there is no role of guardian society in the betterment of the school, the guardian society of the school shall be discontinued. All activities of the betterment of the school will be taken up by the managing committee headed by Srimati Himakshi Deka, ACS Executive Minister. The meeting stands over. My lord, in this meeting, my lord, page 82, my lord, kindly see, page 82, the petitioner himself was present. Rajiv Kumar Doctor, serial number 30. He was the petitioner. He himself was present. Now, my lord, earlier also, my lord, 2014, page 44, my lord, come for the time being. Page 44.
Yes.
It was in 2014, the same deputy commissioner meeting was held, same resolution was taken, where, my lord, Deputy Commissioner Kachar presided over the meeting. The headmaster cum secretary college of school has informed existing managing committee of the school has been dissolved, so and so. And after threadbare discussion, the following decision taken: Inspector of Schools, Kachar CTC, shall look after all financial matters transaction, bank transaction relating to the school. Ad hoc committee has been constituted with the following members. Additional Deputy Commissioner Kachar as the president. 2014 additional DC was the president. And Inspector of Schools is the member, government pleader, headmistress of the school, 2 representatives of the Teachers Association, Vishwajit Datta, Shashwati Bhattacharya, 2 representatives of the school of guardians, Ajit Kumar Dev, Monodur Dev, so and so. My lord, this was the meeting in 2014. Thereafter, my lord will kindly come to page 48 is the bylaw. If your lordship kindly come to my lord, page 52. My lord, kindly come to page 54 of the bylaw. Page 54. Our school bylaw, as last paragraph, last but one, minus 3, paragraph 3. In case of any unfortunate event giving rise to a chaotic situation disrupting the smooth functioning of the school, then the district administration shall be approached. That is how the district administration every time since 2014 have been approached. The guardian and teacher, their minds never meet, my lord. They are opposed to each other always. That is the problem. That's why a bylaw which says district administration will interfere. And in the next page, my lord, page 55 is very relevant. It is in 2019, the same deputy commissioner has constituted a committee where guardian representative Rajiv Kumar Dattu was the president, was the member. He himself petitioner. So, my lord, since 2014, the DC has been constituting the committee.
What does the act provide?
Act says, the act provides, the act does not say DC. It says the managing committee will be constituted by the.
Which act is it?
It is the Assam Non-Government Educational Institution Regulation and Management Act of 2006.
My lord will kindly come to
Page.
It is managed in this book. It will be page 371.
I'll take your lordship to that.
Section 12 will be the Constitution of Managing Committee.
Yes, my lord will kindly come to 12. Hello? Wait. Page kotha bolle?
As your lordship got it,
Yes.
section 12. Subsequent 3, clause 3, 2 representatives to be elected and selected by the guardians from among themselves in a meeting to be convened by the school authority on this behalf. So guardians representative is a mandatory thing, my lord, under the provisions of it. Now DC says no role of guardians here. Guardians, you go and this is a registered society, my lord. They choose somebody as their chosen representative, send them to the MC, and he says he intervenes, and DC, my lord, under the provisions of this act, my lord, he has no role to play. If there is any anomaly, if there is any complaint, the director of the education would be the appropriate authority to look into the matter. Anyway, my lord, the bylaw they are talking about, lord, can a bylaw override a statutory law, my lord? Obviously, it was against the statute of the passed by the legislature, my lord. And my lord, whatever happened, it was in 2014 that cannot justify this action, my lord. Now there is a statute even since the 2006. The statute says that the director of education would be the appropriate authority. By mistake, you approach the wrong authority and he passes order. We point out the same that you are not the appropriate authority. Director would be the appropriate authority.
Where is the thing about the director?
My lord,
Where does it mention the director?
my lord, I will just come to that.
Director is not to constitute the managing committee.
inspection and supervision is section 20. Director or any officer authorized in this behalf may enter anytime with or without notice any place or building or premises which he or she has reason to believe that being used for non-government educational institution, make such examination of place, building or premises, or inspect any place, building, premises, equipment, articles, documents, including financial and transactions, and seize any of such equipments, article, documents deemed necessary for the purpose of examination, investigation, or collection of evidence, and retain them as long as necessary. After making the inspection, the director of this authorized officer or his authorized officer carrying out the inspection shall furnish a copy of the inspection report to the manager or managing committee of non-government education institution to act upon the report and for compliance thereof. Now, even regard to, my lord, utilization of fund, money received by or held by on behalf of the concerned non-government educational institution shall be utilized for the purpose for which they are intended and shall be accounted for by the school authority in such a manner as may be prescribed. Surplus fund. So this is now audit also, the lordship comes to section 22. The account of the non-government educational institution shall be maintained and the audit shall be done in the manner prescribed. The institution shall furnish to the director an audited statement of accounts. So director is the authority in every matter. Even if there is some anomaly or what, my lord, maladministration, director should be approached, my lord, not the deputy commissioner, because there is a bylaw. This bylaw is against the mandate of the statute.
Even under rule section 2012, we cannot form, my lord.
No, supposing, Mr. Roy, if I concede to your prayer. if that-
Interim prayer.
If the interim prayer,
Then only,
that would be upsetting the order of 31st March.
no.
Yes.
31st March, my lord, to 31st March, there is no order as such.
No, there's a stay order.
No, he said, I'm only
If there
said.
is no stay order, then let them go ahead.
No,
I
my
filed
lord.
contempt, my lord. I
My lord,
already
will
filed
kindly
contempt.
see the
If there is
court
no
has
stay order,
passed.
let them also pay the salary of the teachers. They are
No,
running the
my lord.
management.
It says, I am only inclined. So hence I pass this order is not there.
No. Inclined to whatever, but then there's already an order staying the suspending the operation of the resolution.
Where it is, my lord? It is not there.
Page 41.
So page 41, it says, I am having so and so. The court is inclined to suspend.
Yes, inclined to suspend the operation.
But did not say, finally says in terms of order, learned advocate shall submit instruction, then the next day that will pass. The order, if any, because I am inclined, it will be passed on the next day after, because as ordered earlier. That is what the problem, when the court.
There's already suspension of the operation.
That's said, my lord.
Of the resolution.
No, my lord, the problem is, even their committee or my committee, teachers should get a salary. That is no problem.
That is there. But then the minutes, the resolution taken in the meeting on 11/10/2022, that is suspended.
All right, my lord. If it is suspended, then let the inspectors draw the salary, my lord. The lordship will grant it to the inspector. Let the inspector of school be the signatory, neither of us. There is no problem on that. Or district, mission coordinator who is an officer, independent of any of the body. That will not disturb any of the orders. Because the order suspended doesn't mean the earlier order restored. The effect of stay is, and quash is different. My lord. Earlier order doesn't go. The effect of stay, Supreme Court has held, my lord.
That part is different. That part is different. But as on today, that resolution is state.
Okay, well, resolution state doesn't mean the earlier order restored. I am not on that matter. That dispute your lordship will resolve. What I am submitting before lordship is, since the grade 4 employees, the teachers are suffering, let the inspector of school be the signatory for drawal of salary of the neither of us. Let the inspector of the school may be the signatory. That is the only prayer. Till the matter is heard on the next day.
Yes.
My lord, that I have to take instructions, my lord. That
Well,
whether This is a no cost payable. My lord, in my humble submission, the effect of this interim order would be restoration of the earlier managing committee.
Does not. I will
Because the
show to your lordship
resolution
a
is state.
decision.
Means what? The resolution is state means this is illegal, therefore it is state.
No.
They, instead of coming with this vacation of stay application, they should find first of all, they comply with the interim order passed by the court. And then they should have come for vacation. Now, in one hand, they are running the my lord school. Every management affairs, everything is run by this managing committee, which has already been declared as illegal by your lordship and state. And now they are saying we are not able to pay the salary. They comply with this order. State. Yeah. Direct.
My lord, I can show to your lordship is aware of that. My lord. The effect of stay and the Supreme Court, my lord, this Chamundi mopeds, the long back. It's only says that this is earlier order doesn't restore. Supreme Court has clarified.
Who appears? Kaushik, you are appearing? No.
Only my lord the salary part. And then the lordship will next. After 15 days, the lordship will hear the entire matter.
No, I'm thinking of hearing the entire matter.
No, we directly don't have any role, my lord, in this. And moreover, my lord, the Act of 2006, my lord, that also does not specify.
The resolution that is 11/10/2020 is directly in conflict with section 12 of the Act of
My lord.
2006. Correct?
Yeah.
It is in conflict.
My lord, may I just point out section 12 once again? Lordship, 12 is not in conflict because section 12 will lordship kindly see just for a while. My lord.
Section 12C.
No, my lord, section 12. See, lordship will come later. Every non-government education institution non-government education institution is defined, my lord, will kindly have a look at page 576. 576. Page 576. Clause 15, Roman. There lies the problem, my lord. Lordship got it.
No. I'm on a different book. We are using which book?
The same book, my lord, I think.
No. I'm on this brown one.
This is section, section 2, definition clause. And Roman 15.
Oh, there's no Roman 15. Section 2, there's no Roman 15.
Act is some non-government education institutions Regulation Management Act 2006.
This book does not contain that.
Huh?
No,
Yes, section 2.
Says Roman 15.
There's no Roman 15.
There is, my lord, in my book, non-government education Roman 15.
Subclause G is the
Regulation and Management Act 2006.
2006.
My lord, section 2, 15. The definition of non-government education institution. Lordship will find that in the book. Lordship got it. Non-government, may I read it, my lord? Non-government education means schools established and run by individual of association or individuals or any non-government organization, society or trust, except the school established under Article 30. It says established and run by individuals. Here, this school was established long back by few eminent citizens who are not there. So it says, section 12 says, the managing committee would be from that society who is established, but nobody exists. Nobody survived now. That is the problem. So there is nobody about us. That is the problem. That's why we have to approach time and again to the DC. In any case, my lord, lordship will direct the
Yes, Chaudhary, Chakraborty, what do you say?
My lord.
You want to take instructions?
As regards the
I
whatever,
can give you time up to Friday.
my lord,
Up to Friday, I can give you time.
my lord, can it be next Monday?
No, Monday I'll not be here. Let it be Friday.
Friday I'm not.
But so far as, my lord, I think your lordship can,
Tuesday,
No, if she wants to take some time, I can grant her some time.
Tuesday, my lord. If Monday.
Yeah.
Tuesday.
I'll come back on Wednesday, Thursday then.
Okay.
Thursday next week,
27.
27.
Heard Mr. P.P. Roy, Senior Counsel, assisted by MS.
A Chakraborty.
Chakraborty, for the applicant. So, on request made by MS P. Chakraborty. Counsel for the opposite party number?
I'm responsible number 4, my lord.
No, in your IA,
I am the applicant.
for the sole opposite.
I'm
party.
sole opposite party.
Sole opposite party. List the matter, you know. When do you want?
I said 20,
27.
27.
27. Till last. That day will.
Thursday.
decide the matter.
Thursday not right anyway.
Thursday.
27th not right. अपनी booth का
Oh, huh?
बेटा पहले कोई ना बोला।
No, 20. पहले उठो ना।
इसको बराबर हो जाना। इसको बराबर।
Then hearing.
डाला है ऊपर।
Cabinet memorandum I have received. For the approval, Lordship, I pray for some time. Lordship, the memorandum is there.
Cabinet memorandum.
Yes, that I
Has
have
it been
received,
placed before the cabinet?
Lordship. But the approval, Lordship, there, I require some time to place that, Lordship.
Where's the approval?
Lordship, the approval, I pray for some time, Lordship. They'll require some time, Lordship. It is written in point 1, Lordship, regarding the cabinet memorandum decision, Lordship. The first page, Lordship.
Yeah, it says 2 sets of cabinet.
Lordship, that is the
memorandum.
problem, Lordship. It is of 2010, Lordship. That's why they are praying for some time to provide us with the cabinet approval, Lordship.
Yeah, Mr.
Yes, Mr. Karma.
That is Vishwakarma and the counsel for the petitioner. On request made by MS Arbor.
Lordship.
Standing counsel like the government department. Is the matter even after 2 weeks?
4 weeks will be good, Lordship, because
Then
again.
I'll have to release it from Potter.
No, it's okay, Lordship. 3 weeks there.
Lord have almost heard us completely, so.
Okay, then, Lordship.
Better
2
if
weeks.
it's definitely part of it.
After 2
I'll try.
2 weeks.
Problem.
In a date be fixed, Lord.
List the matter again. I'll give a date after 2 weeks. Say about 3 weeks.
Then
Problem.
10
Plus.
13.
The matter relates to derecognition of the NCTE, my lord, which was granted, my lord, way back in, my lord, 2008. This, my lord, the B.Ed Institute, my lord, that is one of the premier institute of the, my lord, district. And my lord, prior to, my lord, this NCTE Act came into force, my lord, this was functioning as per the rules existing at that time.
Now, after coming of the NCTE Act 1993, it has been granted recognition in the year 1998, which has been renewed from time to time. The last one is of 22/5/2015, at page 40, mate. Page 40. Yes. This has been granted, my lord, under the NCTE Act as well as the, my lord, the regulation that was framed in 2014. Under paragraph 3, and whereas the institution which College of Teachers Education Tulsiram so-and-so has by affidavit dated so-and-so consented to come under the new regulation 2014 and sought for one basic unit in B.Ed course. And whereas it has been decided to permit the institution to have one basic unit of 50 students subject to fulfilling the following conditions, namely, so these are the conditions. Now, my lord, while this was, my lord, functioning, my lord,
So by this order, your college was given recognition.
recognition. Initially, it was given in, my lord, under 1993 Act. After it came into force, it was initially given in 1998, thereafter from different orders, and lastly, it was in, my lord, 2015. Now, my lord, the recognition, my lord, that has been, my lord, withdrawn, my lord, on 26/8/2019 at page 52, my lord.
Yes.
Lordship may come to, my lord, paragraph 4, and whereas the institution has submitted a reply dated so-and-so, and in response to the so-called notice received on 1/7/2019 and 12/7/2019, the ERC in its 275th meeting held on 26 July 2019, after considering the matter and observed that the institution is still deficient on the following grounds, that is, approved faculty list is not as per NCTE regulation 2014, as 3 teachers are part-time. Specific ground is that under the regulation, my lord, 3 teachers part-time cannot be, my lord. My lord, this was, my lord, appeal against, my lord, at page 56. There is an appellate provision, my lord. Accordingly, my lord, the appeal was preferred. Then lordship may come to, my lord, page 57.
Yes.
Page 57, second paragraph. And whereas appeal committee noted that appellant institution was required to submit the above documents by a so-called notice dated 21/2/2019. Appeal committee noted that appellant institution has been able to rectify the deficiency relating to approval and appointment of faculty on full-time basis, which is stated as reason for withdrawal of recognition in the impugn order dated 26/8/2019. So defect what was there, the appellate committee found there was no defect, but it had proceeded further. Appeal committee further observed from the building plan and BCC that appellant institution does not possess the required built-up area, which is stated to be 7484 square feet. Minimum built-up area required for conducting B.Ed program with an intake of 50 seats is 1,500 square meters. The built-up area related norms have been in force since NCTE regulation 2009 and are required to be followed by teachers education institution in accordance with clause 8(11) of NCTE regulation 2014.
1 minute.
This reason of building, deficiency in building was not cited, madam, in the show cause notice.
You given show cause?
Not
this?
given.
Okay.
Not given, my lord, there, but the appellate committee said, though the initial order was on the ground on which the recognition was withdrawn, that the faculty list is not as per the approved list, that has been, my lord, found all right. But from the other document, it appeared that the building area is, my lord, there is deficiency in the building area. So thereby, the appellate committee, without, my lord, issuing any show cause notice, my lord, had affirmed the earlier order on the ground of deficiency in the, my lord, land, my lord, built up area.
And whereas appellate committee noted that though inadequacy of built-up area is not cited as a reason for withdrawal, the appellant of its own was required to submit evidence required built-up area as per terms and condition of revised recognition order dated 22/5/2015 and the so-called notice dated 21/2/2019. Appeal committee therefore decided to confirm the impugned order of withdrawal dated 26/8/2019. But this order was challenged before this honorable court. And my lord, by an order, my lord, at page 59, dated 17/2/2021, Lordship may come to my lord, page 61, paragraph 4. May I read, my lord? Page 61, paragraph 4. On an appeal being carried out by the petitioner before the appellate authorities of NCT, the impugned appellate order dated 11/3/2020 was passed. As per the appellate order, the earlier reason of withdrawing the recognition on the ground of approval faculty list as per NCTE Regulation 14 being not available was found to be unacceptable. But at the same time, withdrawal was retained for another reason, that is, institution lacks the required built-up area. In these circumstances, we have to understand that where on one hand the notice were issued to another reason for withdrawing the recognition, but ultimately the appellate authority has accepted the reply given against such reason, but had retained the withdrawal on another reason for which no so cause was issued. So and so NCT disputes the same and submit that some kind of notice was issued, but submission remained not very clear and no so cause notice issued by this NCT pertaining to built up area was brought to the notice of the court. In the resultant situation, if the authorities are under the NCT are of the view that recognition of the petitioner institute is unsustainable because of any such other reason, the NCT would be at liberty to issue appropriate notice to the petitioner institute, and after getting their reply may pass any reason order as may be permissible under the law. Till such exercise is undertaken, the impugned order of withdrawal withdrawing the recognition of the petitioner institute that is so and so shall be kept in abeyance. Now, my lord, pursuant to this, my lord, as because that was kept in abeyance, my lord, I have continued the admission and the courses were going on well, my lord. Then thereafter on 10th March 2021, a so cause notice has been issued, my lord, at page 63. And lordship may come directly to page 64. Yes.
Paragraph 6, and whereas the institution has submitted representation dated 17/8/2020 and 26/11/2020 received on 14/9/20 and 7/12/2020 respectively, ERC in its 290th meeting held on 3rd March 2021 considered the representation of the institution along with order dated 17/2/2001 passed by the Honorable Honorable High Court of Guwahati in WPC number so and so, the original file and related documents in light of NCT Act 93, NCT regulation guideline issued by the NCT from time to time, and decided as under. The institution has not submitted latest faculty list duly approved by the concerned affiliating body and any supporting documents, but only submitted two representation dated 17/8/2020 and 26/11/2020, wherein mentioned that 3 part-time teachers have been appointed as full-time teacher, which is not acceptable. Hence, so cause notice under section 14 of the NCT Act 1993 be issued to the institution to submit reply within 30 days from the date of issue of the so cause notice. And whereas the committee is of the opinion that institution prima facie does not fulfill the requirement and norms and standard laid down by NCT in accordance with the provisions of NCT Act 1993 as detailed above. Now, therefore, the institution is required to submit the individual representation compliance accompanied with an affidavit of on 100 rupees 100 non-judicial stamp paper by the authorized representative of the management. The representing along with an affidavit must reach this office within the time specified at the end. Well, the built-up area that has gone. Now they have again brought up a new ground that the latest faculty list is duly approved by the authority is not approved. These were all submitted. So I have submitted a representation that these are already submitted. So you consider it. They did not do, my lord. Rather, my lord, again, a final so cause notice has been issued. They did not accept my these documents that I have already submitted, my lord.
Now, my lord, at page 66, again, my lord, they reiterated the earlier so cause notice at page 66. Paragraph, my lord, 7 onwards, my lord. And whereas the ERC in its 293rd meeting held on 9 June 21 carefully considered the original file along with other related document NCTE regulation and guidelines issued by the NCTE from time to time and reply in response to so cause notice, observation was made. So cause notice was issued on 10/3/2021. That is the first so cause. The institution has submitted representation dated 10/5/2021 without any supporting documents. I said these documents are already with you. The institution is still deficient in compliance of so cause notice 10/3/2021. Hence, the final so cause under section 14 of the NCTE Act 1993 be issued to the institution to submit reply within 30 days from the date of issue of the so cause notice. So they have reiterated this then, and accordingly, my lord, I have submitted the documents, my lord, which are, my lord, page 68, your lordship will find, my lord. With reference to your so cause notice number so and so dated 11 June 21, I would like to submit the list of all the teaching staff which has been approved by the affiliating body dated 7/7/2021. The hard copies of approved faculty list, all supporting documents of faculties and the affidavit will be sent to you by courier service. Our reply to your so cause notice, which we have received on 28/6/2021, has been delayed due to severe COVID-19 situation and the strict SOP declared by the government of Assam. Hope you would be kind enough to accept our reply later for your kind consideration. But these are the next page onwards. These are the documents which have already submitted with them, my lord. The 69, 68, my lord. And thereafter, my lord, at page 73, they have passed an order, my lord. ERC, my lord. And lordship may come to, my lord, page 75. My lord, the third paragraph, and whereas paragraph 10, my lord. And whereas the ERC in its 301 meeting held on 21st January 2022 considered the original file along with other related document NCTE Act 1993 regulation and the guidelines issued by NCTE from time to time, reply in response to final so cause notice, and the committee made the following observation. After consideration of the documents in compliance of order dated 17/2021 passed by Honorable Guwahati High Court in WPC number so and so, following decision was taken time to time as under. First so cause notice under section 14 was issued to the institution 10/3/2021 on the following grounds. The institution has not submitted latest faculty list duly approved by the concerned affiliating body and supporting documents, but only submitted two representations dated 17/8/2020 and 26/11/2020, wherein mentioned that 3 part-time teachers have been appointed as full-time teacher, which was not acceptable. Final so cause notice under section 14 was issued on 11/6/2021 to the institution on the following grounds. So cause notice was issued on 10/3/2021. The institution has submitted representation dated 10/5/21 without any supporting document. The institution is still deficient in compliance of so cause notice dated 10/3/2021. In response to final so cause notice under section 14, the notices submitted, the institution submitted representation dated 10/7/21 and the documents available on record were scrutinized and observed that following deficiency still persists in the light of NCTE regulation 2014, as reflected on the approval faculty list, etc. My lord, the deficiency what they have found, my lord, page 76, clause B, my lord. On further verification of copy of all approved list session 2018 and 19 dated 31/5/2019 submitted along with letter dated 11/6/2000 in response to so cause notice 14/4/2019 before withdrawal order dated 26/8/2019 and the present faculty list session 2020-21. Following discrepancies have been observed. First 2, 3, 4, my lord, these are, my lord, difference of date of joining and the appointment. of the different faculties. Then, my lord, fifth and sixth, my lord, they try to say that they do not possess the required qualifications. Lecturer at serial number 6, Pallavi Borua, appointed on 1/8/2018, that is after NCTE Gazette Notification 96/2017, does not possess either NET, PhD. Hence, she is not qualified as per NCTE norms and regulation as amended time to time. Lecturer as serial number so-and-so was appointed on 1/3/2019, possesses SLET in 2018, but no NET, NET, PhD as required under NCTE Gazette Notification 96/2017. She is pursuing MEd, hence not qualified as per NCTE norms and regulation as amended time to time. In view of the above, the committee decided as under. In compliance of the order dated 17/2/2001, passed by the Honorable Court of Guwahati in WPC number so-and-so, and accordingly the final so-cause notice dated 11/6/2021 was issued to the institution for fulfillment of deficiency mentioned therein. Even after that, the institution falls short of qualified faculties as required under NCTE norms and regulation for 1 unit 50 intake of B.Ed course. Hence, the decision of ERC taken by withdrawal order dated number so-and-so dated 26/8/2019 for B.Ed course from academic session 2021, which was kept in abeyance by the Honorable Guwahati High Court in its order dated so-and-so, remain unchanged. But again, the new grounds have been mentioned. But their ground was that approved faculty list was not there. So I have submitted the approved faculty list of 2021. Now they have found that there are some discrepancy with regard to dates, with regard to the present one, and the earlier already what they have with them. That is one. And that, my lord, 2 teachers, my lord, allegedly, my lord, they do not possess the certain qualification as required, for which, my lord, no so-cause notices was issued. My lord, they have stated, my lord, on this ground, they have affirmed the earlier order. My lord, the High Court has clearly said if you have any new ground, you give him a so-cause notice. But for this, they have not given. But nonetheless, my lord, Lordship may kindly come to my lord, page 78. I have given the clarification. The discrepancies of the date. And my lord, in paragraph 7, my lord, I have given the lecture, my lord, all the lectures, my lord, what they have, my lord. So far as, my lord, 2 teachers they had mentioned, my lord, in the earlier, that is Pallavi Borua and Nisa Agarwal. Now, your lordship will find Roman 5 is the, my lord, regarding Nisa Agarwal. Regarding lecture at CL number 6, Pallavi Borua, and CL number 7, Miss Nisa Agarwal, as they did not have NET PhD, we have advertised for those 2 posts and appointed Miss Pratiksha Moran and Miss Madhukar Mishra respectively through proper procedure, and the faculty list with newly appointed assistant professor is also approved by the affiliated authority. So here we would like to inform you that we have already accepted the opportunity to appeal and completed on so-and-so, which you have offered by so-and-so order dated so-and-so. My lord, I have already cleared this so far as discrepancy of the dates we have already mentioned. And then so far as the other 2 teachers, we have already, my lord, given the clarification that we have, my lordship will note that for this purpose, they did not issue any my lord, notice. They, my lord, they under the rules, any deficiency they have found, my lord, they have to give an opportunity to rectify. And if we fail, then the so-cause notice will come, and thereafter, my lord, the question of, my lord, withdrawal, etc., recognition, withdrawal, etc., will come. My lord, that provision I'll take your lordship, my lord. Now, my lord, since, my lord, nothing was done, my lord, I have also preferred an appeal, but the appeal was also not heard, my lord. So therefore, I have preferred a writ petition, my lord, will find, my lord, at page 80. Yes. And they said, my lord, they did not receive the, my lord, hard copy, because at that time it was pandemic, my lord, everything was online, my lord. So the hard copy they did not receive. Alam Learned Council has produced the communication dated 27/7/22 from the authorities of the NCTE, which indicate that as mandated by the MHRD notification dated 13/9/2011, the authority of the NCT are yet to receive hard copy of the appeal filed by the petitioner under section 18 of the National Council of Teachers Education Act 1993. In that view of the matter, the petitioner is directed to furnish a hard copy of the appeal to the authority of the NCT within a period of 10 days from today. On receipt of the hard copy of the appeal to be submitted by the petitioner, the NCT shall consider and dispose of the appeal at the earliest. Till the appeal is considered by the authorities of the NCT, the order dated 31/1/2022 shall not be given effect to. Accordingly, hard copy was submitted to them, my lord, and they have passed the final order. You will find, my lord, at page 83. Lordship may come to page 84. My lord. Clause 2, outcome of the case. Appeal committee perused the relevant records and the documents submitted by the appellant institution. The appellant institution filed a writ petition 4691 of 2022 in the Honorable Guwahati High Court, Assam, Nagaland, etc. The Honorable Court by its order dated 37/2022 directed as under. The appellate institution filed appeal dated 12/3/2022 has submitted the following documents with a request to consider it as a compliance of deficiency pointed out in the impugned withdrawal order dated 31/1/2022. Against Ms. Pallavi Borua, we have appointed Ms. Pratiksha Moran having MA in education with B.Ed and NET qualified. Against Ms. Nisa Agarwal, we have appointed Mr. Madhukar Mishra having MSc in physics and M.Ed and NET qualified. Against Ms. Indiriman Dihingia and Amrit Singh Pal, we have appointed Mr. Manjit Kumar Shah and Ms. Tutumon Moran respectively. All these appointments have been approved by the Dibrugarh University dated 6/5/22. This is for your kind information and necessary action. Noting the submission and oral argument advanced during the hearing by the appellant institution on 2/9/22, observed that the institution submitted faculty list is not as per NCTE norms, still shortage of one qualified teacher. Well, one qualified teacher was not a ground for them, my God. And which teacher is not available, that is also not mentioned. It is also observed that principal appointed by the institution is also not qualified as per NCTE norms. The appeal committee noted that ERC was justified in withdrawing recognition of the appellant institution on the ground of the aforesaid deficiency, as the appellant institution has failed to rectify the deficiency. This principal doesn't have the qualification as per the regulation 2014. It is also not a ground, my lord. Since 93, my lord, she has been, my lord, functioning as a principal. At no point of time, even, my lord, under the 2014, they have given the, my lord, recognition in 2015. Nowhere they have mentioned, nor they have ever inspected the institution, nor they have said, my lord, the teacher is not, the principal is not qualified. And it is very vaguely said that one qualified teacher is not there. Under which subject? It is also not mentioned, my lord. We have all the, my lord, teachers. Now, my lord, you will see, my lord, from the my lord, 2019 onwards, they have been, my lord, on one, this issue is so-called notice one ground, and after they satisfied, they, my lord, in the final stage, they, my lord, on the different ground, they affirm the order. This way have been continuing, my lord, though I have been, my lord, taking admission because of the stay orders, and, my lord, the institution is functioning, my lord, as per the rules, my lord, absolutely nothing. Brilliant, my lord, results also, my lord, been producing. My lord, considering all these, my lord, their, my lord, queries, what the institution thought, that instead of approaching this high court immediately, let us, my lord, the principal be changed with a qualified one, and the, my lord, one teacher, though they have not, my lord, said which teacher, we have, my lord, appointed one additional teacher, my lord. These, my lord, new principal appointments have been given, my lord, at page 86. 3 teachers. This Shankar Chatterjee, he is, my lord, appointed as principal. Then, my lord, page 87, one teacher. Page 88, second teacher. Then 89, Nisa Agarwal having qualified, she is again appointed, my lord, 3 teacher. They said 1, we appointed, my lord, 3. And this list is also approved, my lord, that is at page 90. All these documents have been forwarded to them. Well, they did not respond at all, my lord. By letter dated 24/3/2023 at page 93, we have submitted all these documents. They did not respond at all. So, my lord, we are compelled to approach this honorable court. And the prayer, your lordship will find, my lord, in the prayer, my lord, at page 31. My lord, for setting aside the order dated 13/9/22 passed by the appellate authority, order dated 26/8/2019, that is the initial order, and the order dated 31/1/22, that is the final order that has been issued by the, my lord, regional director, my lord. And, my lord, in prayer D, the respondent number 3 shall not be directed to dispose of the representation dated 24/3/2023 submitted by the petitioner institution with a speaking order after giving adequate opportunity to the of hearing to the petitioner. That is one of the prayer, my lord, is that you consider the representation. If you find all these, my lord, documents, my lord, are valid, and now we conform to the rules as per you, though we are already, my lord, in conformity with the rules. But since you have objected, we have given the qualified principal according to you. You asked for, my lord, 1 teacher, we have appointed 3 teachers. My lord, at the time of moving, your lordship will kindly come to the order, my lord, various orders.
In this petition?
Yes, my lord. The first order, my lord, 12/5/2023. Ajay, what's it? 12/5/2023.
Yes.
Heard Mr. So-and-so for the person, also heard so-and-so standing counsel NCTE, respondent so-and-so. This writ petition is filed by the petitioner being aggrieved by the derecognition of the petitioner institution for imparting B.Ed degree course in terms of the objection raised by the NCTE earlier. The petitioner has complied with and rectified the same. That apart, an appeal has been filed against the order of derecognition where it has been categorically mentioned that the deficiency are corrected. However, in spite of such steps being taken by the petitioner, the NCTE has failed to recall the derecognition order. As a consequence, the institution, which is considered to be the oldest in the Dibrugarh district, will not be recognized institution, and therefore it will not be able to take any fresh student in the institution. A representation to that effect has been filed before the regional director by representation dated 24/3/2023, which is, however, according to the petitioner, has also not been disposed of. Mr. So-and-so standing counsel submits that he may be permitted 1 week time to obtain instruction. Prayer allowed, an extra copy of the writ petition be submitted to so-and-so. Accordingly, list the matter on 18/5/2023, on which date learned standing council NCT shall obtain the necessary instruction and apprise the school. The prayer of interim order made in the writ petition will be considered thereafter. Then, my lord, on 18/5/2023, after this order dated 12/5/2023, the council obtaining, my lord, time for 1 week time to obtain instruction. What they have done on 17/5/2023, they have issued an order saying that since the appeal already exhausted and it has been decided against them, there is no scope for consideration of the representation. That was the, my lord, sum and substance. My lord, this court has considered that, my lord. And paragraph 2, your lordship, may kindly see, my lord. And standing council NCT of the order, my lord, of the order dated 18/5/2023, paragraph 2. May I read, my lord?
Yes.
Standing council NCT submits that in deference to the order dated 12/5/2023, he has obtained necessary instruction. The instruction received are placed before the court. Learned counsel referring to these instructions submits that the representation preferred by the petitioner dated 24/3/2023 has been disposed of by the regional director of High Communication dated 17/5/23, and a copy thereof has been sent by email before the authority. Perusal of the order dated 17/5/23 reveals that representation was disposed of on the ground that the appeal preferred by the petitioner institution has already been disposed of by the appellate committee after perusal of the necessary records and documents, and therefore remedies available to the petitioner under the NCT Act has been availed of, and no further cause of action survive in the matter, and nothing is left to be delivered deliberated upon with regard to the grant of recognition of the institution. The copies of the instruction furnished by Mr. So-and-so are kept in record of the case. When counsel for the petitioner submits that the present writ petition has been filed assailing the order dated 13/9/2022 passed by the appellate committee, whereby the appeal filed by the petitioner institution was rejected on 2 counts, namely shortage of 1 qualified teacher and the principal appointed by the institution does not have qualification as per NCTE norms. It is submitted that these orders passed by the appellate committee is without issuance of proper show cause notice in that regard. Inasmuch as by the earlier show cause notice issued, the institution was asked to show cause on other deficiency. However, the impugn order has been passed by the appellate committee on a ground which is not included in the earlier show cause notice served. Being every present writ petition has been filed, be that as it may, since it is submitted by the learned counsel for the petitioner that all the deficiencies have been rectified and the number of qualified teachers as mandated under the NCTE Act, read with regulation and the rules have been given appointment and principal presently appointed also possesses the requisite qualification. Prima facie, it appears that there can be no ground not to continue with the recognition granted earlier to the institution by the NCTE authorities. Accordingly, Standing Council NCTE is permitted to obtain required instruction as to whether the relevant record documents in support of the submission of the petitioner that the deficiency shown in the impugn order dated 13/9/2022 by the appellate committee has been rectified in the meantime by the institution are available in the records available in the office of the NCTE. These instructions be placed before the court on 29 May 2023. This instruction never placed before this court. Mr. Standing Council NCTE is also permitted to file their counter if so advised. Other respondents, including the state respondent as well as the university, are also permitted to obtain required instruction and file necessary affidavit if so advised. Further order in the matter will be passed upon instruction as may be placed by the NCTE by the learned Standing Council NCTE. In the event no instruction are furnished by the learned Standing Council as directed, the petitioner will be at liberty to renew the prayer for interim order on the next date fixed. It is further submitted that the appropriate department of state would be education department. So my lord, the instruction never came, and subsequently some instruction has come. On the basis of that, my lord, they have filed an affidavit. But so far as the instruction that was sought, that whether you have received these documents by which, my lord, it has been submitted, that the 3 new appointments have been made and the principal has also been, my lord, appointed. My lord, this has not been, my lord, even in the affidavit, my lord. And very, my lord, basically, Lordship will kindly come to the writ petition. Paragraph 26. Internal page 23.
Yes.
Paragraph 26, page 22. That the petitioner states that from the narration of the facts stated above, it is apparent that the respondent authority is most illegally and actuated with malafide time and again has been harassing the petitioner by affirming the show cause notices or confirming the original order by the appellate authorities, inasmuch as the show cause notices are issued on some unfounded ground and thereafter final orders are passed on some other ground, which never existed in the show cause notice. Similarly, the appellate authority also, while considering the appeal again affirmed the order of the primary authorities on different ground, which were either not existed in the show cause notice or on the final order. Therefore, the petitioner apprehends that this time also the petitioner will face the same situation in case of the aforesaid order dated 13/9/2022 is put to challenge in appropriate forum. Therefore, the petitioner, with a view to end the conflict, decided to rectify an deficiency pointed out by the appellate committee. Accordingly, on 27/11/2022, an advertisement was issued for the post of principal and 3 faculty teachers, and after following the procedure, appointed Dr. Shankar Chatterjee as the principal of the petitioner number 1, and also appointed 3 faculty teachers, namely Ms. Pallavi Datta in the post of assistant professor pedagogic paper, Mr. Vivek Torcha, assistant professor in foundation course, and Ms. Nisa Agarwal as assistant professor in pedagogic paper science. And accordingly, the said appointments are also approved by the respondent number 7. Well, this paragraph has not been replied at all. It is deemed to be, my lord, admitted that It was, my lord, actuated with malafide. These so-called notices were issued in some ground. They have been, my lord, issuing the orders on some different ground, either the original order or the appellate order. Then all the deficiency, notwithstanding, my lord, the right to challenge. Well, these deficiencies have been, my lord, clarified before approaching the court, and this list is also, my lord, approved by the university. This has not been denied. And what, my lord, discernible from the, my lord, affidavit, only ground that under the regulation, my lord, 2014, my lord, I have to have a, my lord, qualified teacher. Well, my qualified teacher all along, my lord, it has come in 2014 only. It is applicable to the new courses. And I have been, my lord, running this institution since 1993. It was all valid appointment. And at no point of time, even they have given me the, my lord, recognition under the 2014 regulation. They did not mention anything all these days. Therefore, my lord, the question of, my lord, giving me an opportunity does not arise at all, my lord. And now what is the provision, your lordship will kindly see, my lord, the under the act, my lord, 1993 act, my lord, NCTE 1993 act. A new institution and the existing institution, they are having a two different footing, my lord.
Yes.
On the first, lordship may kindly come to, my lord, 14, my lord. Recognize the section, this regulation 14, my lord.
1992 Act.
Yes, my lord. Section 14. I'm sorry, not regulation. Section 14.
Yes.
Recognition of institution offering course of training in teachers education. Every institution offering or intending to offer a course or training in teacher education on or after the appointed day may, for grant of recognition under this act, make an application to the regional committee concerned in such form as and in such manner as may be determined by regulation. Provided that an institution offering a course of training in teachers education immediately before the appointed day shall be entitled to continue such course of training for a period of 6 months if it has made an application for recognition within the said period and until the disposal of the application by the regional committee, the fee, etc. so and so. So, my lord, there's two conditions. One is the new, and another those who are existing. They have also have to make an application, but then they are allowed to, my lord, run the institution for 6 months, and thereafter, after fulfilling the necessary conditions, my lord, they'll grant, my lord, the recognition. Now, if it is not fulfilled, my lord, that procedure is also there, my lord. Subsection 3. On receipt of an application by the regional committee from any institution under subsection 1 and after obtaining from the institution concerned such other particulars as it may consider necessary, itself, if it is satisfied that such institution had adequate financial resources, accommodation, library, qualified staff, laboratory, and that it fulfills such other conditions required for proper functioning of the institution for a course or training in teachers education as may be determined by regulation, pass an order granting recognition to such institution subject to such condition as may be determined by regulation. Or if it is of the opinion that such institution does not fulfill the requirement laid down in subclause A, pass an order refusing recognition to such institution for reason to be recorded in writing, provided that before passing an order under subclause B, the regional committee shall provide a reasonable opportunity to the concerned institution for making a written representation. Every order granting or refusing recognition to an institution for a course of training in teachers education under subsection 3 shall be published in the official gazette and communicate in writing for appropriate action to such institution as to concern examining body, the local authority or the state government and the central government. Every institution in respect of which recognition has been refused shall discontinue the course of training in teachers education from end of academic session next following the date of receipt of the order refusing recognition passed under clause B or subclause 3. Every examining body shall on receipt of the order under subject grant affiliation to the institution where so and so, this will not be relevant. So, my lord, the basic thing that if you want to refuse, you inform him that what is the ground. If they fail to do so, then you don't give the recognition and you publish it in the official gazette. Well, this test I have already crossed in 1998. This has come in 1993. The act has come into play in 1993, and when it functional, first time they have given in 1988. This hurdle I have crossed. So they did not say that I am deficiency. The recognition order also I have taken to your lordship. It does not speak anything. Now, so far as section 13 is concerned, your lordship will come. Section 13. This is for the only existing institutions. Inspection. For the purpose of ascertaining whether the recognized institutions are functioning in accordance with the provisions of the Act, the Council may cause inspection of any such institution to be made by such person as it may direct and in such manner as may be prescribed. The Council shall communicate to the institution the date on which inspection under subsection 1 is to be made, and the institution shall be entitled to be associated with the inspection in such manner as may be prescribed. The Council shall communicate to the said institution its views in regard to the result of any such inspection and may, after ascertaining the opinion of that institution, recommend to that institution the action to be taken as a result of such inspection. All communication to the institution under this section shall be made to the executive authority thereof, and the executive authority of the institution shall report to the council the action, if any, which is proposed to be taken for the purpose of implementation of any such recommendation as is referred to in subsection 3. Here, my statement, specific statement, they never inspected the institution. They never given me an opportunity to, they did not show me the defect what is there in the institution, nor given an opportunity to rectify it. But straightway, what they have done, they have gone to the section 17. Where the regional committee is on its own motion or on any representation received from any person satisfied that a recognized institution has contravened any of the provisions of the Act or the rules, regulation, order made or issue thereunder, or any condition subject to which recognition under subsection 3 of section 14 or permission under subsection 3 of section 15 was granted, it may withdraw recognition of such recognized institution for reasons to be recorded in writing, provided that no such order against the recognized institution shall be passed unless a reasonable opportunity of making a representation against the proposed order has been given to such recognized institution. Provided further that order of withdrawal or refusing recognition passed by the regional committee shall come into force only with effect from the end of academic session next following the date of communication of such order. Then 3, once a recognized institution is withdrawn under subsection 1, such institution shall discontinue the course or training in such education, and concerned university or the examination body shall cancel affiliation of the institution in accordance with the order passed under subsection 1 with effect from the end of academic session next following the date of communication of the said order. And the 4 is if it is continued, then there is other penalty provisions are there. So what section 17 says, it must have a report from its own source or whatever, my lord. This is, my lord, is altogether different concept, my lord. So far as existing is concerned, my lord, that section 13 has to be, my lord, be there, my lord. The inspection has to be there, or my lord, the reasonable opportunity to clear the deficiency should be there. And then, my lord, if I fail, of course, since it is contravened now, then you take the recourse to the section 17. That particular steps they have not taken in the instant case matter. And the apex court in 2012 year has made a clear distinction between the existing institution and the new institution. I'll take a look straight way to the paragraph 22 matter. Paragraph 22. Once recognition has been granted by regional committee to an institution, the council has to ensure that such recognition institution function in accordance with the 1993 Act. To achieve at that objective, the council has to get inspection of the recognized institution done periodically. And if such institution is found wanting in the functioning as required, then recommend to the institution the remedial action to be taken by it as a result of the inspection. In view of the above statutory scheme, it is hard to appreciate the litigious approach of the council and the present controversy. If the council feels that the function of the inspection under section 13 may be performed by regional committee, it can so provide by invoking section 26 or section 27 as the case may be. What is clear from the provision of 1993 Act is that post-recognition an institution acquires a different position. On recognition by the regional committee under section 14 and on affiliation being granted by the examining body, once the recognition institution starts functioning, the interest of teachers, employee, and the students intervene in order to ensure that the recognition institution functions in accordance with 1993 Act, the 1997 rule regulation, and the condition of recognition, and the same time functioning of such recognized institution is not disturbed unnecessarily. The provision for inspection and follow-up action pursuant thereto has been made in section 13. By section 13, as a matter of law, it is intended that the council ascertains whether the recognized institutions are functioning in accordance with the provisions of section 1993 or not. For that purpose, it empowers the council to cause inspection of such any institution to be made by such person as it may direct, and in such manner as may be prescribed. The council may authorize the regional committee to carry out the function of inspection, but such inspection has to be made as prescribed in Rule 8 to find out whether such recognized institution is or not functioning in accordance with the provisions of the 1993 Act. So, section 17, it may be for a new institution or any contravention of the provisions has been detected by own motion or otherwise. Now here they have not detected anything. Only from the lastly what Lordship has seen, 2 lists they found the discrepancy of date. I have given the explanation. Without giving a so-called notice, they said 2 persons teachers are not qualified. I have replaced them, my lord. Then final order they now say that no, the principal do not have the qualification, which are never questioned, my lord. Then said one teacher is deficient in shortage of 1 teacher. We have replaced it by a qualified teacher. We have appointed 3 teachers. So, my lord, humble submission, my lord, this order, my lord, being, my lord, violative of principle of natural justice as well as, my lord, the section 13, my lord, and clear direction from the court by the earlier order of 17.2 that if you find any new ground, you give him a so-called notice and then you take action. No such action has been taken by. And now, my lord, the earlier 2 occasions, Lordship, as I have taken your Lordship. This court has, my lord, state the, my lord, order. They firstly they kept the, my lord, derecognition order at abeyance. So therefore, I have continued to take admission. My lord, I have been functioning, and thereafter it had come before Lordship. Lordship had state the withdrawal order, directing them to dispose of the appeal. So therefore, I continued the, my lord, taking admission, etc. Now the admission have come, my lord. Recently, my lord, on 13/7/2023, my lord, I have to submit particulars, my lord, that I have. No, this one, other one. Okay. This B.Ed result has been, my lord, declared on 13/7. And prior to that, my lord, on 7/7/2023, I have received a, my lord, notice. My lord, this will be more relevant, my lord, 7/7/23.
Yes.
To the, this has been issued by the university, my lord, University, under which I am affiliated, my lord. the principal of the college institution affiliated to permitted to Dibrugarh University offering B.Ed program regarding NCTE recognized status of admission to the NCTE recognized B.Ed program for the session 2023-24. Madam Sir, with reference to the subject cited above, I would like to request you to furnish the latest NCTE recognition status of your college institution regarding admission of the NCTE recognized B.Ed program for the session 2023-2024. A letter in this regard may please be sent to the undersigned along with a copy of the order received from the NCTE and approved intake capacity in B.Ed program. Well, this has to be submitted latest by 13/7/2023 and on 13/7/23 find the B.Ed results have been declared. Now students will take their admission in the different affiliated colleges. So far as I am concerned, I'll be failing to submit this because that has been withdrawn. And if I miss this chance, for 2 years, I'll not be able to take admission. The staffs are there, the institution is there, investments are there. Then also the reputation of the institution is also concerned. So I pray that this particular order may be set aside. They take a decision on the documents what I have submitted if they find, or if required, they let them make an inspection, and whatever they find, they give me an appropriate opportunity of rectify the deficiency. And if I fail to do so, then you take the recourse as per the act. And my lord has otherwise, my lord, matter would not have been so urgent, but since in the earlier occasion, Lordship had stayed the recognition order, but at the same time, Lordship has observed that no student will be admitted. So therefore, my lord, this particular, I will not be able to take the admission.
We'll continue on Thursday again.
Right.
We have some. Yes, Alam, are you ready? Come prepared on Thursday. We'll have to dispose it out. How about the other councils, the Dibrugarh University?
They are basically formal parties. They don't have, once this recognition is granted, they'll at the payment.
In fact, Dibrugarh University is required matter.
Why?
Because they have granted them a permission to admit the student matter. So they have to clarify that. Then
Who is the Mr. Majumdar?
Majumdar.
Madam, I will inform him matter.
Yeah.
Otherwise,
Make
also he will not be required because Lordship has seen the letter dated 7/7/2023. By that, I have been asked to, among other documents, the recognition order. I have, and they have not cancelled my affiliation. That is still valid. Therefore, the letter has been sent to me. So they don't have as such to say. But then, since my friend is insisting, I'll also inform. He'll also inform it.
In fact, it will be better.
Cycle Senior Counsel Assistant Prime Minister
A.K. Gupta.
A.K. Gupta, Learned Counsel for Education. Also heard Mr. I. Alam, Learned Standing Counsel, NCTE. Stop. 13 part. This for 13 again on 20. 22. 20.
Part.
Yeah, part
On when, my lord?
20. Day after 20.
Or day after?
Okay.